Happy 4th of July to everybody out there. Hope y'all have some nice barbecues and everything goes all right today. Hopefully everything goes okay for y'all on 4th today. Welcome to another episode of Behind the Wheel. And as promised, last week I promised that I was going to put something on my channel based on our rights, Constitution. Okay, I didn't copy down the Constitution, but here's another thing based on. Here's another situation based on the decision that the Supreme Court made. And once again, tune in to more next week also. All right.
Guns in America. It's a 6-3 rule. Okay, so we do have one decision handed down by the U.S. Supreme Court. It deals with guns in America. It's a 6-3 ruling, but we have not seen the opinion yet, Dana. At issue here was New York State Rifle and Pistol versus Bruen. It's the biggest gun control case the court has had in 14 years. At issue, 2 gun owners in New York had their applications denied based on a failure to show what is considered a proper cause. In states like New York, to carry a concealed weapon outside of the home, you need special permission to do that, and these men were arguing that's a violation of Second Amendment rights. So the court holds, here we go now, the court holds that New York's proper cause requirement to obtain a concealed carry license violates the Constitution.
Yep.
By preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. That's the ruling 6-3. It'll affect states like New York and about 7 others that had similar restrictive rules.
This is a significant, big case. And I know we have Jonathan Turley, and I believe we have Shannon Bream with us. So we'll get them here in just a moment. Just let me set up one thing, and then we also have Andy McCarthy. This is really good. So it's 6-3. And one of the things that happened in this case, and Jonathan, maybe I'll go to you first if you're able, is that the gun rights activists, once they started down this road, they might have realized at some point, as I remember reading, that they might have actually hurt their cause here, because this decision it kind of, for the gun rights people, it kind of backfired. For people who were wanting people to have more self-defense rights, it seems that they have won in this Supreme Court case.
They have won, and it is an interesting point that you make. New York has been the gift that keeps on giving for gun rights advocates. They, like D.C. and Chicago, have lost major cases before the Supreme Court. This was a case that many of us rode on when it was in the lower courts. I thought that it would result as it did today, that this was a case that clearly was unconstitutional under the controlling authority of Heller. And what you have in jurisdictions like New York is there's a very strong gun control effort, but they often produce cases that, quite frankly, are welcomed by many gun rights advocates, because you can create, in their view, this was a bad case to make some good law, and they did so. This is a 6-3 decision. You have Justice Thomas looking at the history of the Second Amendment, looking at the holding in Heller, and saying that the answer is clear, that you cannot impose this burden on gun owners to be able to carry a concealed weapon.
Jonathan, stand by here. I know you and Andy McCarthy and Shannon Bream are reading through this, through the opinion right now. And Shannon, I want to go to you, but just to put a headline here, in a major ruling for gun rights, the Supreme Court has sided with these 2 gun owners in New York, saying that they're striking down, rather, the restrictive gun law in New York State. Shannon, to you, what do you read?
Yeah, what had happened is these two gun owners were looking for the opportunity to carry a concealed weapon. They had other licenses and other things that allowed them to carry their guns for specific reasons. But they said, I just want to be able to carry one. I think that that's my constitutional right. But in New York, you had to have a special showing. You had to have a reason to say that you had a justification for carrying a gun in a concealed way. Well, they said there shouldn't be those restrictions. If I'm a law-abiding citizen, I should be able to carry. So in striking down that New York law and essentially sending this case back down, here is what Justice Thomas, writing for the majority 6-3, says. He says the constitutional right to bear arms in public for self-defense is, quote, not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. And he's used this language before, talking about the fact that he thought that the Second Amendment was in some cases being treated as a second-class right. He goes on to say, we know of no other constitutional right that an individual may exercise only, excuse me, my computer here, only after demonstrating to government officials some special need. That is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It is not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him. And it is not how the Second Amendment works when it comes to public carry for self-defense. So he says New York's proper cause requirement, or that this special showing that you have to carry a gun, violates the 14th Amendment in that it prevents law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms. The dissent is written by Justice Breyer. Of course, he is just days away from retirement. He's joined by Justices Kagan and Sotomayor. Haven't read his dissent yet. It's about 135 pages long, but we're getting there. That's the headline ruling. Bill, a big win for gun rights advocates.
Just picking one line out here, Shannon, from Justice Thomas. The government will have to show, he says, that a gun regulation is, quote, consistent with this nation's historical tradition of firearm regulation, which goes right to the Second Amendment. To Andy McCarthy now, and your reaction, Andy.
Well, I think this is a faithful rendition of what the Second Amendment is, which is really the most misunderstood amendment in our public discourse, I think, Bill. You know, the Second Amendment is not a right to bear arms so much as it is an acknowledgement that there is a pre-existing right to bear arms that existed and was derived from natural rights at the time the Constitution was ratified. So it's not a positive grant of a right. It's an acknowledgement of a right that already existed, and it's a prohibition on government from regulating that right. So if you're within the ambit of the right to keep and bear arms as it was understood, the idea is not the government's doing you a favor and allowing you to defend yourself. The point of the right is to limit the ability of government to disarm the public in terms of that ambit of what the Second Amendment protects. So, you know, our discourse seems to presume that government has a right to regulate as long as it's reasonable. And what the Constitution says is, no, you have a right to defend yourself, and the Second Amendment is a limitation on the government, not a limitation on you.
Interestingly, in looking at this, Jonathan, I wanted maybe a little bit of a two-part question here, which is, this is seismic for a lot of reasons, especially because it's not just New York. These are the other states where it would have an effect. California, Delaware, Hawaii, Maryland, Massachusetts, New Jersey, and Rhode Island. And when you have a case like this that has such a seismic impact, how long does it take for a state, those other states or even New York, to change its rules? As of today?
VectorVest is calling you to be different. Don't listen to the gurus. Don't play by their rules. Don't play their game. Don't do it. They'll tell you the market doesn't have trends. They'll tell you there's always something to buy. They'll tell you to buy stocks that are falling and to buy even more as they continue to drop. And when you lose...
Does it change?
Oh, those are presumptively unconstitutional, and they should be changed. But the question is, they really can't be enforced to the degree that they contradict this decision. This is a momentous decision for gun rights advocates and for the Second Amendment. It has all of the elements that you often associate with a Thomas opinion. He brings up sort of originalist history, swatting back arguments from later and after the ratification as largely irrelevant to understanding the intent behind the Second Amendment. But most importantly, the court rejects a two-part test for looking at limitations on gun rights and stresses you need to presume that people have a right to exercise individual rights like gun possession. And that means that you can't put the sort of thumb on the scale, as New York did here, and say, show us that you have proper cause, including moral standing, to have a gun. And what the court really hammers at is that this would not be tolerated with other rights in the Bill of Rights. And there is a tendency among some judges and many legal analysts to treat the Second Amendment as something less than an individual right. And what Justice Thomas is saying here is that this is an individual right with the other rights in the Bill of Rights. And we don't like shifting the burden to people to say, prove you need to use this right.
Back to Shannon and Andy on this. I mentioned this first case regarding guns of significance before the court in 14 years. And Shannon, in 2008, they ruled that the Second Amendment guaranteed individuals the right to have a gun at home for self-defense. And now this ruling essentially addresses whether the individual can carry the gun outside the home. And Shannon, after living in New York for the past 20 years, I can tell you, for those, whether they support or against the Second Amendment, living in New York, if you wanted to get a gun, it wasn't impossible, but it was pretty close to it.
Yeah, exactly. And that's been the issue, that these two gun owners who decided to push forward with this case said, you know, there are those who are, whether they're lawmakers or celebrities or sports stars, whatever they are, those folks are usually either have their own security or they're able to get this particular concealed carry license that they need so they can protect themselves. And part of the argument was, why should everyday American citizens not have the same right to protect themselves if this is about self-defense and wanting to conceal carry? New York did permit other licensing that would allow you to transport guns for hunting and gun clubs and those kinds of things. But when these two, and I believe one of them is actually a gun instructor, came forward and said, listen, we are responsible, law-abiding people who know how to handle guns safely. We have great respect for them. Why should we then be disadvantaged in that we can't carry a gun for our own protection? So that was definitely a big part of the argument. In looking at the dissent, it goes exactly where you think it would. It begins with statistics about shootings and deaths by gun in America and where that takes us. But that seems to be the majority, wholly apart from where they're going in the majority opinion. As I said, Justice Thomas has said in the past that he thought that the Second Amendment was being treated as a second-class right. And for a long time, the court has not taken a gun case, and there has been a lot of pressure. A number of gun cases have bubbled up. And even in not taking the cases, Justice Thomas and others have said the fact that we won't even address these, we're not treating this right like we do other constitutional rights. And it's time for us to take one of these cases and make one of these decisions. So here we are, 6-3, a very big decision. And it comes at a time when this country is really grappling with the debate, with horrific incidents in Buffalo, in Uvalde, and now a gun bill that is sitting there in the Senate and could get a vote today.
I was just thinking about that vote today. That could happen at any moment. In fact, Schumer, the Senate majority leader, does plan to call it up, and there would be about 30 hours of debate. It could actually be voted on finally tomorrow. Andy, one thing I've noted here is that in the dissent, Justice Breyer refers to Uvalde and Buffalo, and apparently, I know you haven't had a chance to read 135 pages in the last 3 minutes, but Justice Alito has a retort regarding Buffalo because, and I'm assuming what that has to do with is the responsible gun owners who can legally carry a firearm. That's what this case, this specific Supreme Court case, is about.
Yeah, I think that's right, and I think considering that part of the dissent and picking up from what Shannon just said about statistics and bringing the fact pattern up to the modern day, I'm reminded of what Justice Scalia said in Heller, which is that, look, we have this Second Amendment which protects a pre-existing right to have self-defense in the form of firearms that are in common use. Now, we could amend the Second Amendment. We could change it so that it would allow firearms that are even beyond what's in common use, or we could amend it and take it out of the Constitution. But the court's obligation is to give effect to what the Second Amendment says as it was originally understood when it was adopted. So all this stuff about, modern circumstances and statistics, and what I think the court is saying is, fine, amend the Constitution if you're not happy with the Second Amendment, but our job is to give effect to what the Second Amendment says as it was understood when it was adopted.
Okay, thanks to all three of you for the quick reaction there. Just reading one more thing here, Dan, I think is relevant from Justice Thomas's decision. Nothing in the Second Amendment distinguishes between home and public with respect to the right to keep and bear arms, which was the question that was before the court. Interesting, Chief Justice Roberts voted with the majority at 6-3, and also apparently it's Justice Thomas's birthday today.
Hi, everyone. I'm Brian Kilmeade. I want you to do me a favor. I want you to click to subscribe to the Fox News YouTube page. This is the only way that I know for sure that you're not going to miss any